Uh, Good evening and welcome to tonight's session. So we would like to discuss some questions in the land law, because having regard to time availability vis-a-vis the fact that you have a barely 2 months, so to speak. We will have to be handpicking questions and topics as they come to us. So tonight we would like to do a land law. So we have a question to discuss. And let me say that in a sense, the Land Act came into force. There has not been any question on land law yet. So it was last year where it was rumored by, of course, not rumored. Some of you have written it before. So those who were going to write it, we probably heard that the question had been changed or something like that. And what we heard from some of you was that the question, I think, included a land law question. Having seen it, but they said that it was something about lease or something like that. So what that means is that whoever your examiners are or are interested in taking the examination also to land law, especially so when they change the format into just 2 questions. We haven't had land law so far, as far as my memory can confirm, unless I'm mistaken. Yeah, so let's suppose that you have like a question as we have here. A group of investors from the US are planning to set up maybe factories in Ghana, but they are concerned about the certain state of the law relating to land in Ghana. Sorry, I just started reading at where I am. I don't know if it's reading at your end. So the sound quality may not be that great, but let's manage. Yeah, so the question I was reading was that a group of investors from USA are planning to set up various projects, including factories in Ghana, but they are concerned about uncertain state of the law relating to land in Ghana, especially in the wake of enactment of Land Act 2020, Act 1036. Prepare a full memorandum briefing them on current state of land law with particular reference to issues that may be of concern to them as investors that would need land for their investment projects. Okay, so this is this is a made-up question. It doesn't mean any question from anywhere. It is a made-up question. Those who sat last year, I think I discussed this question with you as well. Yeah, so this is what I want us to do. Supposing you have a question like this, what are the points which will have to be discussed? Now, as I have indicated before, anytime you have a question, be it an essay question or problem type question, you need to take a bit of time and put your thoughts together. Just get your points dotted before you think of like the arrangement. The other preliminary point I'd like to make is that students who have written the entrance examination before, some get worried by certain certain question task masters, which are put in the question, and it serves as some kind of like a, detracting or diverting their attention from the core. So for example, here, I included prepare a full memorandum, right? So some students, as soon as they see a memorandum, they see a brief, they see this or that, they get agitated and they are worried. Oh, but I don't know how to do this particular one. Now, I dare say that those things are not important. Whether memorandum, whether a brief, a digest, or whatever is put there. Because remember, you are LLB graduates, and at the LLB level of legal education in Ghana, we have not yet taught you drafting, right? Drafting will be done at the professional stage of legal education, at least as far as the bifurcation of legal education is concerned in Ghana. So don't be so worried about those kind of like drafting concern. What is important is the substance of the question. So get this thing clear. If you see memorandum, if you see those things, don't get so worried about it. What is important is what the question is really, really about, not the particular form which the question, if you like, is asking you. Of course, if you know it, that is fine. But if you don't know it, it's not really important that you are going to fail. No. If, for example, this question said, prepare a full memorandum doing this, and let's assume you have no idea about how a memorandum is crafted, how it is written. So you get worried that then you are going to fail the question. No. If you have written the required points, you will never fail such a question just because you don't know how to write a memorandum or anything like that. So let us keep that in mind, students. Okay, so having made these preliminary observations, let's tackle the question together. So I'd like you to raise up your points and then I'll comment on them, on their propriety or otherwise. Good. So if you are ready, just put up your hand or you can just unmute yourself and talk, but make sure that it's only one person who is talking at a time. Yeah, you can unmute yourself. Yeah, so what points have you put down? Or the question has taken you by surprise? At least we're doing some learning of the land law, and the Land Act is 2 to 3 years now. So you have some reasonable familiarity, especially those of you who completed school last year and are also completing. Anybody? Am I alone here?
No. Doc.
Yes.
This is Joshua.
Okay, Joshua, welcome.
What I will do is that I'll first of all tell them, okay, in memorandum form, it's always from and then to. So the heading will be memorandum with date at the top. Then you state from maybe so and so to. Then I'll tell them about the four types of land titles that we have in Ghana. That is the freehold, family lands, two land, and then the allodia. Then from there, I'll move on to tell them that the number of years that a foreigner can acquire land in Ghana. That is 50 years according to our constitution, 1992. And then these are the few things that I think I have some few ideas about.
Okay, Joshua. Yes, at least you have a reasonable idea, but you talk about, yes, I'll come to you, Safer, just 1 second. Just run a commentary on Joshua's contribution. You said 4 types of land, and I heard you talking about family land, talking about this. You see? No, you said like for interest. Did you say interest
Yes.
or types of land?
Interest.
Interest, okay. Now, if you are talking about interest in land, you must always start from section 1 of the Land Act 2020 at 1036. At least, when they're coming to force of Act 1036, we have an authoritative statement of what interest one may have in land in Ghana, okay? And these are in section 1. The allodial title, and you mentioned that the common law freehold, customary law freehold, is virtual interest, leasehold interest, and customary tenancy. So these are the range of interests which one may have in land in Ghana. But of course, as to whether you are a citizen or not a citizen, some may not be available to you, but we come to that. Yeah, so those are the things I wanted to comment on in the response by Joshua. And okay, I think Joshua also alluded to the constitution. He didn't mention the provision, but certainly he's thinking of like the provision which relates to interest in land by acquisition of interest in land by like the foreigners as it was. So I will take few other more, and then I will see the feature which is emerging. Then we wind up on that and move on to another one. Okay, Cephas, your hand was up.
Yes, Doc. Good evening.
Good evening.
And good evening to my colleagues.
Yes.
Please, with respect to the question, I would like to tackle the points I've been able to raise so far.
Okay.
First of all, I would like to advise the particular group of investors to register
the
with
foreign
the registrar.
investors, yeah.
Yes, the foreign investors to register with the registrar in general to get a legal body to operate as a company in Ghana. Secondly, what they should note in respect to the Land Act 2020 is that certain restrictions have been made on foreigners with respect to acquisition of land, especially with the period or the duration of the land tenure. So I would like to take us through some few of them. If we look at Article 266 and then the Lands Act, it has restricted foreigners from obtaining a freehold interest in land in Ghana here. Now the question will arise as to who a foreigner or a non-citizen will be. If we look at Section 10, subsection 10 of the Lands Act, it has defined a citizen or a company that is a citizen to include a company with its equitable shares, 60% belonging to Ghanaians. So where that particular foreign investor company has its shares above 60% of, let me say above 40% belonging to the foreigners, then it will be deemed to be a foreign company and they cannot acquire any freehold interest in Ghana here. Also, renewability of leases. Usually they will enter into a lease agreement with the transferor, and it is implied under the New Lands Act that once you are a non-citizen and land has been transferred to you, then there's no renewable clause, or let me say that it is not implied that the lease is automatically renewable. I'm referring to Section 50, subsection 17 of the New Lands Act. So that particular provision has also precluded the right to renewability of a lease that is entered by a foreign company. I think this is basically what I have to present.
Okay. All right. Thank you, Cephas. Yeah, I think you've covered some good points, which will make a good response to a question of this nature. But maybe what you didn't have to worry yourself about is the company law dimension. Because the question was only concerned about you telling about the state of the law. But then where you have like a marking scheme, if a student has covered the basic things needed and the student goes extra mile, such students or such candidates always attract additional marks from examiners. It's raining heavily here. I don't know if it is coming through the sound. Does it affect your hearing?
No.
It doesn't.
Yes, please.
All right. Okay. All right. That's fine. Yeah. So that's it. But otherwise, CFAS, that is good. Yes. Any other? Yao, Sapon.
Hello, sir. Good evening,
Yes.
sir. Please, I want to make some comment on the CFA's opinion that he just expressed. He talked about acquisition of freehold. Foreigners are barred from acquiring freehold lands in Ghana. But I think in the Act, freehold is, in fact, there is no freehold. Nobody can acquire freehold in land in Ghana. With respect to foreigners, it's a lease term for a number of years, which is 50 years. So they can only acquire a lease term of 50 years, not necessarily a freehold interest.
Okay. Okay, so all right, thank you, Mr. Sapon, for because if we look at the session 4, it's talking about, we have the 2 types of freehold in Ghana, the customary freehold and then the common law freehold. And you know that the customary law freehold, you can no longer have it in respect of stew or skin land. And again, for common law freehold, it cannot also be held in respect of stew or skin land. So those are basic things that we have to keep in mind.
Yeah, Doc,
yes.
I want to add up to what my friend just said. If you go to Article 266,
because it's really heavily here, so I struggle to hear you.
Yeah, I'm saying that if you go to Article 266 of the 1992 Constitution,
yes,
ownership of land by non-citizens. If you go to Article 266, Clause 4, the 50 years is explicit over there.
Yes.
That is what I just want to add. We mentioned the authority, we mentioned the Constitution, but we are not emphatic about the article.
Oh, right.
Yes. Article 266, Clause 4. That is what the law says.
Right. Okay. Any other points? I think there are some important points which are missing, but let me hear you. Yeah, we've had a good number of them, but there are some very useful points missing. Any other?
I think these are the few things.
You see, all the time when you have a question, you have to demonstrate that you understand what the question is inviting you to. See, so far, I have not heard from your responses awareness or appreciation of some of the challenges, right, or problems which bedeviled our land sector, leading to reform and adoption of this new law. Because if you look at it, it's embedded in the question. So therefore, in your introduction, right? Your introduction, it will be useful for you, among other things, to explain how land law has been reformed radically the last 3 years. Of course, these are just a background to your discussion. And then you try and give hints about problems which drove the reform and the mischief the reform seek to address. You remember, we have problems like multiple sale of land and so on and so forth. You have problem of like the fraud related to various land transactions, and even where you have like no documentation and all those things. And again, you also have to give a brief account or appreciation of the Pre-Land Act 2020 state of the law. Because we have had a certain state of affairs as far as land law is concerned before the coming into force of Act 2020 on 23rd December 2020, when this law was actually entered into force or was signed. So what were some of the major challenges or the major issues as far as the Pre-Land Act 2020 state of law is concerned? The fact that we had a diverse statutes, various or scattered legislation on various aspects of land law. If you remember, various legislation here and there. And again, when it comes to being customary land law, for basic things, you have to come through a couple of like decided cases before you get certainty regarding the incidents and features of particular interests in law, is that customary law, and so on and so forth. And then another thing associated with the Pre-2020 state of the law is that we also had the two state guaranteed land ownership regimes. We have like the deed registry. Deed registry, that is Act 122, if you remember. The requirement that any instrument affecting interest in land, must be registered before that instrument will have a legal effect in terms of admissibility if there is any litigation relating to land and so on, so forth. And how we also had a system which was meant to render redundant or no longer necessary the deeds registry at some point. That was the land title registration or land title registry, which was supposed to bring a scheme into place so that if that land title registration scheme is fully rolled out in the country, various interests, various transactions relating to land will have actually been documented in the land title registry. So mind you, what the deeds registry under Act 1226 to do is not to register ownership itself. It's just to register a document, instrument, trying to say something about an interest or someone who claims to have some quantum of ownership. It's just to register a document, maybe a lease or any instrument relating to land that yes, this statutory declaration or this or that was registered. But beyond proving that it was registered on that particular date, the registration of that document per se is not determinative of who is the true owner or proprietor of the interest to which the document purports to signify. So that was the deed registry, that 122 scenario. So if you look at it, things registered under 122, more of evidential purpose in an attempt to prove ownership. Then we had a land title registration law in 1986, PNDS law 152, which was supposed to have, have a system in which various interests from allodia and all other range of interests. If you look at section 19 of the repealed at PNDS law 152, were supposed to have been registered after rigorous and robust verification and investigation by the Land Commission, so that once you get the various interests in the land title registry, if you are going to buy land or do a search and it says that that parcel of land at Blackberry or over there belongs to A or B, you can put complete reliance on it, because the title will be said to be indefeasible. Indefeasible means that it is conclusive if your interest has been registered and that. So that was the the picture and so on. That was the picture. Now then you come to talk about of course, these things I am saying are also in addition to the points we have discussed from Joshua, from Cephas, and from Yao Sapon. So I am directing your mind to some of the relevant points which are omitted from their contribution. Otherwise, apart from that, I think the points which have come up so far are useful. But maybe another interesting or relevant point to also touch on is the fact that now when you are going to acquire any interest or interest in land being transferred to you by a married person, it is now a legal requirement that the other spouse must consent in writing. And that is important, because let's say that the foreign investor or whoever is going to acquire the land, going to acquire from Madam A, who claims to have like a 20-acre land, which can be used to set up all manner of projects or whatever. But then it is also evident that Madam A is not single. Madam A is married. Then the Land Act 1036, especially if you look at section 47, it will tell you that a transfer without consent in writing by the other spouse is not valid, and so on. So these are also matters that you need to canvass. So as it were, if you look at the question, of course, is broad, but then it also gives you room to actually show a deeper appreciation of Act 1036. And another thing which did not also come out in our discussion is the effort by the new law to try and protect parties to land transaction against fraud, right? Against multiple sale and all that. So if you look at section 277, as well as section 12, right? Look at section 12 and then section 277, you notice that various offenses have been created where a person decides to, for example, do multiple sale or decide to indulge in any fraud in relation to documentation relating to land and so on and so forth. So these are some of the things that you should also remember and include in your response to a question like that. Any other points which you think needs to be included and we haven't talked about it? Anybody?
I think that is it.
Okay. Okay, so let's take this other question. The National House of Chiefs have invited you to make a presentation on how Land Act 2020 Act 1036 has modified interest in land at customary law, as well as innovations made by the Act with respect to customary land management. Write your speech for the presentation. So this is another question which also challenges our appreciation of customary land law, especially before Act 1036 and customary land law under Act 1036. So what points will you consider necessary? And then the question is straightforward, isn't this a speech? So you don't need to worry about any, as I said, the styles or the stylists are not very important. It's the meat, the heart of the question. So it doesn't matter whether it is a speech or it's a memorandum or it is a brief or digest or whatever. It's a substance which is really important. Yeah, so who will try first?
Yeah, Doc, I'll try.
Yeah, Joshua.
Yeah, he said, Doc, I'll still talk about
those who are not contributing, at least my experience with this online revision sessions, the past 3 years, right? The past 3 years or 4 years is that those who are active, they pass, okay? At least those who are very active, I know all of them, they made it. So I want all of you to be active. So on that note, Joshua, continue.
Yeah, I will still talk about the 4 types of interest in land and then move to the customary law interest. That is in the old act, the old act that is amended talks about if you want to alienate a land.
But in the old act, let me correct this. The old act is not amended. The old act is repealed.
Okay, repealed, sorry.
Okay. So that's a footnote remark. When a legislation is amended, what it means is that that legislation is in force, except that some changes have been made to some aspect or some provisions of it. So that is, if you like, amendment. But then where you have a legislation which has been abandoned and then we have a new one in place, then that is a repeal. And then we have like a new one which has replaced the repealed one. So on that note, Joshua, continue.
Yeah, the position of the old act is that in alienating a land, one, you have to first be a member under the allodia. You have to first be a member. You have to be there should be head of family in consultation of elders, principal elders of the family. Then a member of the family can protect the land and use it for farming purposes. But the current position of the Land Act is that under the allodia, a member of the family can also alienate a land. It can also alienate title of a land. That is what the little I can talk about it. Say.
All right. Thank you, Joshua. Any other? Yes, Mr. Sapon.
Sir, please, the new Land Act has actually ensured establishment of customary land secretariat under Section 14. That is one part of it. And under Section 32, that's the management of two lands. What it means is that the chiefs who are custodians of the land have been made fiduciary. In that matter, anything they do, they must be transparent and fair.
Okay.
And it has also criminalized some acts. When they engage in, they'll probably be held responsible for it. They could even go to jail.
Okay.
And the new Land Act has also drawn a distinction between customary freehold and usufructuary interest. Before, it was used interchangeably, but now the new Land Act has drawn a distinction between the two usufructuary interests.
Yeah, so I mean that's very important, Mr. Sapon. Yeah, those are very, very, very important points, which will definitely feature in any answer to a question like this. That's very important. Yeah, so as you can see, it's talking about two aspects. Yes, yeah, I think there are two participants. See, yes. Why? Yes, go ahead. No, is it no, CFAS? CFAS. Yes, CFAS.
Yes,
Yes.
Okay, I would like to add up to what my colleagues have already stated. In starting this particular question, I would have stated the various interests in Section 1 and moved on to pick customary law in its entirety. That's the customary law freehold. Then I'll indicate that Section 7 of the New Lands Act has made some changes to customary law tenancy. Previously, the Bunu Abusa was having its own customary rules where certain persons could take only the proceeds and the land still belongs to a transferor. But in this case, Section 7 has made it that Abunu Abusa has become like a contract. So it depends on the agreement that is reached by the parties that will determine the finality at the end of the day. Then Section 13, that's accountability. From the previous decisions of our courts, it has always been that holding family head, or let me say, holding these people accountable for proceeds or certain actions that they have taken in respect of lands that are kept in their trust was very difficult and tedious. In fact, from Finn and Gardiner, it was not possible until the family head accountability law came into being. But Section 13 has made it possible that the stools and then the families and the clans, whatever we have put in their hands, they are in fiduciary with us, and they can be held accountable at the end of the day. And then Section 13 has also made one particular important amendment to the Head of Family Accountability Law, that's PNDC Law 114. Previously, before a person who is not a family head would sue in respect of family property or holding a family head accountable, and the person is not an occupant of the stool or has that part or has been clothed that authority to do so, then there would have been some reasons that the court have stated, and then some of which were that maybe the family head has some issues with the other sector of the family. The family head is possibly doing it because he has an interest and those one. But Section 13 has restated that particular law to include certain conditions that must be met for the family head to render account if any person at all who is qualified under relevant customary law has brought an action for accountability. And then the use of lanyards. Previously, there were no laws that prohibited the use of lanyards, even though their actions, as a resultant effect of their actions, could be criminal. There were no laws that are prescribing the actions or the use of lanyards. So Section 12 has come to prohibit it. And then, like one of my colleagues have stated, Customary Law Secretariat has been established by the New Land Act. I'll end here.
Okay, all right. That's fine. My advice to all of you is that as far as land law is concerned, if you don't know anything at all, or if you've forgotten, okay, make sure that you are sufficiently familiar with Act 1036. Of course, Act 1036 is not the whole of land law, but if you know Act 1036 in terms of examinable things, what will be lacking will be the cases. But at least in terms of like the principles, in terms of the principles, you will be secure. So if you have not yet read Act 1036, it's still not late and it's not that bulky. Okay, just about 283 provisions. They are not a lot, and you still have time. So I will suggest that you take interest in reading Act 1036 cover to cover, and especially as you are learning. Now, I have some program questions maybe in the coming days or weeks when we come back to land law, which I will discuss with you. But those program-based questions, just like what we are doing, will also require that you have a proper mastery of the Land Act. So if you haven't read the Land Act, or if you haven't actually taken it serious, I would advise that you do that. And particularly so, as we got a hint that last year, they nearly brought a land law question, but for the fact that they canceled the paper and then they set another paper, okay? So who knows whether this year you have a land law question or whatever. So for your land law preparation, the minimum, right? The minimum that you can do is first the Land Act. And then when you finish, you take your textbook for the major topics, leases the various principles, just get the one key cases each. But at least for modest revision, if you haven't gone to land law in a long while, read Act 1036 cover to cover. So these are just a very general thing, but there are topics in relation to lease and also registration of ownership interest and also deeds or instruments, which I would like to discuss with you maybe in a lecture format in the coming days, because I noticed that I don't know whether in the law schools or the law faculties, these days it appears that some schools, they don't cover that. So some students do not have any idea, or they don't appreciate registration of interest and also registration of deeds very well. But that is very important because it's examinable either as a program-based question or as an essay question. And the other thing which we also have to take serious is the compulsory acquisition, right? Compulsory acquisition. That is another important one which we have to look at. And of course, the recent Ojidium case, the case between the Ghana Telecom and Ojidium Branu, and insists there's an aspect of the compulsory acquisition. So that is another area that we have to also discuss. So as it were, I have directed you to what you need to pay attention to if you haven't been doing that yet. So once you get your Land Act, you get sufficiently familiar with your Land Act, then we are making very good progress. So let us keep that in mind. Then the other comment I'll make is also that it's not enough to just have the points the question requires. You must also structure your answer properly, okay? You must structure your answer properly. And the structure would also depend upon the effort you have made to understand the heart of the question. So you look at this question, for example, you notice that it's talking about two things. The fact that there has been modification to interest, which may be held in land at customary law. That is one. And then the fact that there has been innovation. So the two are not the same. Modification means that there has been some tweaking, right? Some adaptation or some changes to what we knew already under customary land law. And then innovation also means that there are things which were never part of the law and they have been introduced, you see, for the first time. So in your presentation of your ideas, this will have to come out clearly. And those who contributed towards the discussion, I think that some respectable effort was made by some of you to do that. So that is fine. Because of time, otherwise we have moved on to question 3, but I'd like you to take question 3 and think through it so that next time we meet, we'll be able to discuss it and also have a lecture. So to what extent does the Land Act 2020-1036 provides panacea to problems and dissatisfaction that landowners encountered during compulsory acquisition, or when the state triggered the doctrine of eminent domain. So think about this, and we will meet in the course of the week, God willing, and then we continue with our class. So thank you for coming. Be nice being with you. Have a good night.
Thank you too.